Everyone, I'm Alonzo Martinez, Associate General Counsel at HireRight, and I'm here with Nicole Campion, Associate Counsel at HireRight. Welcome to On the Fringe, the third installment of our Background Screening 101 series. Quick reminder, today's session is presented for informational purposes only. It's not legal advice, but it should give you a strong foundation and talking points to take back to your teams and your legal counsel. As always, a few quick housekeeping notes. To get HRCI or SHRM credit, you'll need to stay for the full live session. Credit information is going to be emailed to you next week. We're not sharing today's slides, but we will send you a link to the webinar recording. If you have any audio or video issues, hit F5 or use the Q&A icon. Doreen and Carrie are on standby to help you if you have any problems, so just hit that F5 to refresh. And as always, we'd love your feedback. So please take our short survey at the end. It'll help shape our webinars coming later this year and beyond. So here is what On the Fringe is all about. Today, we're gonna dig into screening practices that aren't always front and center, things like credit checks, social media reviews, or age-related questions, but still carry legal risk if they're mishandled. More importantly, we're focusing on what the law restricts, when you can and can't run a credit check, how salary history bans and wage transparency laws affect hiring, what to know about age-related inquiries, how states limit the use of sex offender registries, and what to watch for in social media screening. We're going to end each session with what I like to call a do this, not that discussion, so that you can walk away with actionable tips. At least that is our goal. We want to give you something to kind of lean on. So let's dive in, and remember, get your questions in using that Q&A icon. We'll cover those at the end of today's presentation. Let's talk about credit history. This is one of the most tightly regulated and often misunderstood tools in background screening. Employers often use credit reports for roles involving financial responsibility or access to sensitive data, but doing so comes with significant legal obligations. So let's break that down. Employment credit checks, they are not the same as personal credit scores. While they come from the same place, the credit bureaus, the reports are built specifically for employers. So they include payment history, current debts, bankruptcy, and recent inquiries, but no credit score, no income, no unpaid medical bills. That's a big one. We get that question a lot. Again, they do not include unpaid medical debt, and no personal demographic details. For candidates, these are also soft inquiries, so they don't affect an individual's credit file. Credit checks are generally used for positions requiring financial trust, but just because it's possible doesn't mean it's always permitted. There are a patchwork of laws that limit when and how employers can request these reports. At the federal level, the Fair Credit Reporting Act, or the FCRA, governs how credit reports can be used in employment. So the FCRA doesn't prohibit their use, but it does set strict procedures for accessing them. So just a quick recap on what's required under the FCRA. You have to give the candidate a clear standalone disclosure. You have to obtain their written consent. If you take adverse action, like rejecting the applicant based in whole or in part on their credit report or anything in the background report, you have to follow the adverse action process, which includes providing a copy of the report and a chance to respond. You also need to certify to your background check provider that you have a permissible purpose and won't use the report in a way that violates the any equal employment laws. Speaking of which, let's talk about the Equal Employment Opportunity Commission, or the EEOC's stance. While the EEOC hasn't banned credit checks, it has warned that they may create disparate impact discrimination, especially if they disproportionately exclude candidates from certain racial or ethnic groups. So that isn't a hypothetical risk. In a case, the EEOC v. Kaplan Higher Education, the EEOC sued over credit check practices. It lost the case, but the challenge highlights the agency's concern. The key message here is that credit checks have to be job-related and justified by business necessity. So what's our compliance takeaway here? You should only use credit reports for roles where financial responsibility is essential. Don't rely solely on job titles. You want to analyze the actual duties behind that job. You want to document your rationale. If challenged, you're going to need to show that the check was relevant to the job. And finally, keep in mind that the Consumer Financial Protection Bureau, or the CFPB, oversees the bureaus themselves. That means if a candidate disputes an item on their credit report, the FCRA requires you to pause any adverse decision while that dispute is resolved. So here's our bottom line. There's no federal ban on credit checks, but there are strict guardrails. The FCRA sets the process, the EEOC defines the risk, and the CFPB ensures fair handling. So next up, Nicole's going to cover how state laws add another layer of complexity. Nicole?
Thank you. Yeah, so state laws approach this a bit differently. We currently have 12 states, in addition to Washington, D.C., and Puerto Rico, who have what we kind of broadly refer to as credit history bans or credit history restrictions. What these laws typically do is they will prohibit employers from ordering or using credit history in an employment decision, or from requiring consent from employees or candidates for a credit check as part of an employment decision, so forcing them to sign a consent form for it. Now, some of these laws will also add additional requirements. So you may see additional disclosure requirements, you may see additional adverse action requirements, and we'll talk through a few of these states in just a little bit more detail in a couple of minutes, just so you can get an idea of what they may look like and how those requirements really change from jurisdiction to jurisdiction. They're really just not the same, unfortunately, across the board. Now, this really isn't an area of the law that's changing frequently. I think our last addition to this map was about 6 years ago with Puerto Rico. That was 2019. But that doesn't mean it will never change. So even though you don't hear really frequent updates about, brand new credit restriction bans like you might some of the other topics we talk about more often, it's still a really important area of the law to keep your eyes on if you do order credit history as part of your employment screening process. The other thing to keep in mind with these, they all have exceptions. So just because one of your jurisdictions may show up on this map in red, it doesn't mean you can never order a credit report on anyone who you ever hire. Each one has exceptions, and the exceptions will be pretty unique from state to state. But there are a few concepts we see carry through a lot of them. So I want to just take a couple minutes to talk through what we'll call the common exceptions. Now, again, states may add to this list, they may take away from this list. They may take this list and add their own twist to what it says. So, for example, a state may define the dollar value of the funds that someone has to have access to. They may take the access to trade secret or confidential information exception and change it to be proprietary information or personal information. They may define what a managerial role is in a way that really isn't what you necessarily would think of. So it may be a lot broader or a lot more narrow than just anyone with a manager title within an organization. And almost every state who uses the substantially related exception will define what that means actually pretty explicitly. Most of them will actually have a list of the conditions or the positions where ordering a credit report may be substantially job related. So just something to keep in mind there. We're going to talk really, really quickly through about 7 of these states, so about half of the jurisdictions that have laws right now. We're going to focus on laws that not only have restrictions, but also add requirements to those restrictions, just to give you an idea of the different kinds of things you might see. If you order credit reports as part of your screening program, I strongly encourage you to give our white paper a review. It will give you an overview of all of the laws that have, or all of the states that have laws on the books, and also give you a lot more detail than we're going to be able to cover in the next 15 or 20 minutes. That should be linked for you in the resource center or in the resource section of the webinar, so give that a look. And with that, we'll kick it off with California. So California has 2 laws that are relevant and specific to credit reports in employment decisions. You have the Labor Code, and the specific citation is up on the screen for you. And then you have the Consumer Credit Reporting Agencies Act, the CCRAA. Now, this is not to be confused with the Investigative Consumer Reporting Agencies Act, the ICRAA, or ICRA. Very similarly named, acronyms are off by only 1 letter, so it makes it a little bit confusing, but keep in mind they are different. ICRA applies to all background reports ordered in the state of California, whereas the CCRAA, the one we're going to talk about today, that's specific to credit reports. So a pretty important distinction. Just keep that in mind as you're going through this and as you're looking at your program. So California Labor Code says employers cannot order credit reports unless the position the person is being considered for meets one of the criteria the Labor Code defines. And we will look at those in just a moment so you can see what types of things are on that list. If you order a credit report in California because you have positions where that criteria does apply, you're going to have some additional disclosure requirements to comply with. And you can see them on your screen. California actually tells us what has to be in that disclosure, which is nice to know what the state expects. And I won't read through all of them, but I do want to call your attention to the second bullet point. So in the California credit disclosure, you have to identify the specific basis under the labor code. So those points we're going to cover in just a second, for which you're using the credit report. So a little different than what your FCRA disclosure may look like. That may just say, we're going to order a consumer report about you for employment purposes and kind of leave it there. California takes it a little bit further when it comes to credit reports. So remember, your California credit report disclosure will need to be a little bit different. And this will carry through. You'll see it in some of the other states we cover too. It's pretty common for the state credit laws to say you have to disclose the purpose for using the credit history. So just something to keep an eye on. Adverse action requirements are fairly similar under the CCRAA to the FCRA and ICRA. So if you do take adverse action, of course, give them a review. There's a little bit of nuance in there, but for the most part, they're generally pretty similar. So what are the permitted uses in California? Here they are. Right off the bat, you should notice a couple of the ones from our common exception list that we started off with. And you'll also start to see what I was talking about when I said the states may put their own twist on some of those common exceptions. So for example, the last bullet, California is one of the states that's put a dollar amount on access to funds. They've also defined whose funds, it's theirs or a customer or a client. The bullet above is another good example. They've taken that trade secret or confidential information when we talked about really briefly at the beginning. And for California, it's confidential or proprietary information. And California does go into specifics on what that means. So if you do operate in California and you order credit reports, especially if this is an exception you're going to rely on, make sure you give the statute a read and make sure that your definition of confidential and proprietary aligns with what the statute says. It was a lot of text. You would have needed a magnifying glass to read the screen if we tried to throw it all in there. So it is not all up on the screen for you, but it is all in the statute. So make sure you give that a look. Moving on to Colorado. Colorado takes a slightly different approach from California to their credit history law. So in Colorado, employers can't use credit information for employment purposes unless it is substantially related to the current job or the potential job, probably depending on whether it's an employee or a candidate. Employers also can't require an employee consent to a credit report as a condition of employment, unless one of the exceptions applies. So there are 3 exceptions to this piece. One is where it's required by law. 2 is where they are a bank or a financial institution. So you'll remember those from the beginning. And then 3 is where you have a bona fide purpose for ordering the information and using the information, and the information is substantially related to the current or potential job, and you provide written disclosure. So that's where the specific disclosure requirement for Colorado comes in. If that's the exception you're relying on, you'll have to disclose to the candidate that you'll be ordering the credit information and the purpose for ordering it. Colorado also has an adverse action requirement that's a little bit different from what the FCRA has. This actually reminds me a little bit more of what I would expect in like a ban the box fair chance style law than in like the FCRA or a law like that. So there are 2 pieces to this. The first is very similar to the FCRA. You have to notify the candidate of the adverse action. We already have to do that under the Fair Credit Reporting Act. But Colorado adds for credit reports, you also have to inform the candidate of the particular information you relied on when you made that decision. So there's one other important piece here. Colorado defines how you have to do this, which is a little bit unique. In Colorado, if you take adverse action against someone based on their credit report, and so either an employee or a candidate, if it's an employee, you have to provide the adverse action in writing. But if it's a candidate, you have to provide it in whatever the method was they submitted their job application. So think about all the different ways you may take in job applications. That may also be all of the different methods you have to put out adverse action notices if you take adverse action based on credit reports. So a kind of unique twist there, something to keep in mind. Now, Colorado defines substantially related for us. So if you're ordering under the exception that the information is substantially related and you have a bona fide purpose, this is what substantially related means. There are really three key categories, again, kind of reminiscent of the ones we talked about in the beginning. The first one is a little bit more nuanced than just managerial position, but it's certain executive or management personnel or their staff as it fits into that group. The second one is unique to Colorado. This is for certain federal government contracts. So if you have certain federal government contracts and you're hiring folks to work those contracts, just keep an eye on this one. This might be for you. So make sure you give the statute a read if you operate in Colorado. Now, Connecticut, somewhat similar to Colorado, employers can't require consent to a credit report unless an exception applies. And these are those exceptions. You'll notice that 3 of the 4 are very similar to Colorado. So in the bottom right, you have your substantially job-related exception. This comes with that same additional disclosure requirement. So if you order based on this exception, where it is substantially related and you have a bona fide purpose for using it, you will also have an additional written disclosure requirement in Connecticut. The unique one for Connecticut that I just want to call out, because it is unique and different from Colorado, is the bottom left corner of your screen. This is a kind of misconduct type exception. This is for employers who have reason to believe that an employee has done something specific that would constitute a violation of the law as it relates to their employment. So again, just a kind of unique exception in Connecticut, definitely different. And Connecticut also defines substantially related for us, but they do define it differently than Colorado. So this is a really good example of why you can't just take these terms and apply them across the board. Just because a state says if it's substantially related, that's an exception. It's different from state to state. So it's really important to look to the state level and look at these state level definitions before you decide to start ordering credit reports, because these state definitions really could be the difference between it being allowed and it not being allowed. A couple unique ones on Connecticut I'll just pull out. This is the first time we've seen providing an expense account or corporate card as something that may make a credit report substantially related. We will see that again, but this is the first one. And the one that I find most interesting is actually the last one. So I just wanted to touch on this really quickly. We talked about how access to funds is a pretty common exception. Connecticut actually provides for access to non-financial assets to potentially be substantially related to someone's job. So this is non-financial assets, think pharmaceuticals, think museum collections, things of that nature that would be valued at over $2,500. So again, just a unique one, something I thought was interesting for Connecticut. Now, Maryland is similar to Connecticut and Colorado, but with a bit of a twist on it. So Maryland has 4 exceptions. The first two will now sound very familiar. It's if it's required by law or if you're a financial institution. The next 2 are very different. They've added if you are a credit union share guarantee corporation or an SEC registered investment advisor. Those are the 4 exceptions for Maryland. So unless one of those 4 exceptions apply, employers can't order or require consent for credit history in connection with employment decisions unless, first, if you have a bona fide purpose and the information is substantially related. I think you're probably getting pretty familiar with that one as we go through these slides. The one that's unique for Maryland is the first bullet, actually. If the applicant has received a conditional offer or any offer, really, of employment, and the credit information won't be used for a prohibited purpose. Now, Maryland's prohibited purposes are denying employment, discharging someone from employment, or determining compensation or some other term or condition of their employment. So a very interesting approach that Maryland has taken here, again, sort of similar to Connecticut and Colorado, but not quite. So another really good example of how different these really can be. And like the last few states, if you're ordering based on that substantially job-related requirement, this carries the same disclosure requirement as the last few. You will have to disclose it in writing to the individual and let them know what the purpose is for ordering the report. So Maryland defines substantially related and bona fide purpose together, which again is a bit different. We haven't seen that yet. No one has actually defined bona fide purpose in connection with substantially related in one big chunk like this. Not a lot super unique in the Maryland ones compared to what we've talked about recently, so I won't spend a lot of time on this slide because we do have a few more we want to get to. But if you operate in Maryland, make sure you give these a look if you intend to order credit reports. On to Oregon. Now, Oregon actually has both a statute and an administrative rule on this topic. So if you operate in Oregon, important to make sure you look to both of those and give them both a read as you're deciding whether or not you can order credit reports. Employers in Oregon can't use or obtain credit reports, again, unless an exception applies. One of those is the substantially job-related exception. We'll cover the rest in just a moment. And just like the rest, if that is the exception you're relying on, that it is substantially job-related, you'll need to disclose this to the candidate in writing along with the reasons for it. So here are Oregon's exceptions. Pretty small list. The thing that is unique in Oregon that is really important, I think, to call out, you'll notice the last bullet is their substantially job-related exception. Oregon does define this for us, but it's very limited compared to what we've talked about so far. So in Oregon, substantially related means evaluating with respect to each position, which I think is pretty true when you're making this analysis across the board. But what's unique to Oregon is it's only substantially job related if you're providing access to financial information that isn't customarily provided in connection with a retail transaction that is not a loan or an extension of credit, or if it's required as a condition of your insurance or a surety bond or fidelity bond that you're obtaining. That's it. That is the entirety of the definition of substantially related in Oregon. So definitely a different approach to substantially related than all the other states we've covered so far. So again, good to keep that in mind. Vermont takes an approach that's a little more similar to California than to Connecticut, Colorado, Maryland. Employers in Vermont can't inquire into or use anyone's credit history, of course, unless an exception applies. And the disclosure requirements apply across the board. So no matter which of the exceptions that we'll cover in just a moment, no matter which of those exceptions you qualify for, you have to comply with these disclosure requirements. So you will need to get written consent every time you seek a credit report and disclose your reasons for ordering the credit report in writing. They also have an adverse action requirement that's just a little bit different than what we see under the FCRA. So you have to, of course, still disclose that you're taking adverse action, but also the reasons for adverse action based on the credit report. So just a little bit of a difference there. These are the exceptions to the law in Vermont. I think this is the first time we've seen payroll information as an exception, so an interesting addition for Vermont. But the one I really want to call your attention to is the second bullet from the bottom. So you'll notice that Vermont doesn't have a substantially job-related exception. None of these say substantially job-related in them. But it has the second one from the bottom, which is if the employer can demonstrate the information is a valid and reliable predictor of performance in the specific role. So perhaps this is Vermont's take on the substantially related one. We did talk about how they were going to change, those common ones change from place to place. But it is different and it is unique and it will require a slightly different approach. So if you operate in Vermont, make sure you keep this in mind, right? Substantially related is a slightly different concept under the Vermont law. And last but certainly not least, Washington. So in Washington, it is actually Washington's Fair Credit Reporting Act, the WFCRA. So the WFCRA, the state level FCRA, applies actually to all background reports. So the law itself in its entirety is not limited to credit reports, but it does have a provision that is limited to reports with information that bear on credit worthiness, credit standing, or credit capacity. And what that section of the law says is that you can only order reports with that type of information if it is required by law or substantially job related, and you disclose your reasons for using it in writing. So similar disclosure requirement there. Interesting note in Washington, they don't define substantially related for us. So with all those other states, we had that nice list of all of the different things that may make a credit report substantially related to a position. We don't get this in Washington. So something you'll need to think about and analyze if you are considering credit reports in Washington. All right, so the do this, not that section, boil it all down to some best practices. What do you need to think about? Of course, comply with the law. I think this is probably the best practice I can give you. If the law says you can't do it, don't do it. So that's going to be your first one, right? Where it says don't request credit checks for roles where there is no legal exemption. Make sure you know the laws that apply to you, right? That's really, really important. Check all of these state laws. And if they do apply, make sure you understand the exceptions and all the little nuances of each one so that you can, evolve your program to align with them. Keep in mind that the disclosure requirements and the adverse action requirements may be different. They are in addition to the FCRA. The FCRA doesn't go away just because a state has a credit history restriction that imposes more. They are more. They're on top of. But keep in mind, these laws may require you to identify specific purposes for ordering credit reports. If you take adverse action, you may have to identify the information that led you there or your reason for it. So keep that in mind and make sure you're doing those things, especially in the states where they're required. And make sure that your credit inquiries are substantially job-related and based on a bona fide business need. Alonzo touched on this in the beginning, so I won't spend too much time on this one, but this one's really important, right? Curiosity about your applicant's credit history is probably not the best bona fide business need. So make sure you're thinking through this really well. Document your decision and what your bona fide business need is, and then make sure you apply that consistently. Similarly, with using credit as a predictor, think back to that Vermont exception, right, where you can use it as a predictor of performance for the specific position, or where it's allowed if you're going to use it as a predictor for trustworthiness. Make sure you document your rationale there and then apply it consistently to everyone who's applying in that position, right? You don't want to cherry pick the people you're going to apply the rule to. Do it at the position level. So Alonzo, do you want to take us through pay equity and pay transparency?
Absolutely. Thank you, Nicole. And some really incredible information there for us. I just wanted to note that we're getting some really great engagement from our audience. So if you do have questions, get those questions in using the Q&A icon. I was trying to answer some of those live while Nicole was giving us our state update. There is a lot of information at a state level regarding credit requests. So again, take a look at that white paper. That's the credit check white paper available in the resource section of this webinar. So yeah, let's shift gears and talk about pay equity and pay transparency. We're going to walk through what these laws are trying to fix, how they differ, what employers may need to consider to stay compliant. I want to start by drawing a clear line between two terms that often get lumped together. That's pay equity and pay transparency. They're connected, but they're not interchangeable. So look at the screen. On the left is pay equity. That's what I consider the goal. It's about making sure employees doing similar work are paid fairly, regardless of gender, race, or other protected traits. The standard here isn't just equal work. Many states now use comparable work, which is broader and allows for cross-functional comparisons. On the right of the screen is pay transparency. I like to consider that the tool. It gives employees and applicants visibility into how compensation decisions are made. So this includes things like salary history bands, pay range postings, and obligations to disclose benefits in certain cases. So here's our bottom line. Pay equity is about fairness. Pay transparency is about visibility. And the more visibility you provide, the more pressure there is to make sure your pay practices can stand up to scrutiny. So let's talk about salary history bands. This is one of the earliest pay transparency reforms. So on this map, you see states in red, which restrict when and whether employers can ask about a candidate's prior pay. So this isn't a fringe movement. You can see this on the screen. These laws are now widespread across the United States. Again, the idea is really simple. When you base a job offer on prior pay, you're kind of baking in existing inequities into your comp structure. So these laws aim to break that cycle by requiring employers to focus on the value of the job and not on the candidate's past salary. These rules usually fall into what I like to call like three buckets. There's the first one, which is no asking. You can't ask about prior salary during interviews or on applications. The second is no relying. Even if the information comes up, you can't use it to set the offer. And third, no justifying. You can't point to past pay to explain disparities between employees doing comparable work. So if you're hiring nationally, be careful. The law often follows the location of the candidate, not just your corporate office. Again, think about the location of the candidate, where they're actually working. So that means even remote roles posted nationwide can bring these bans into play. Want to be careful about the scope there. So let's shift to pay disclosure requirements. The map shows the states that now require you to disclose pay ranges, usually in job postings, but sometime upon request or at other stages in the hiring process. If you're hiring in one of these jurisdictions, even just advertising your remote role, you might be obligated to include wage ranges and sometimes additional compensation information. I'm going to get into the details next. So here's what you need to know at a very high level. First, coverage thresholds vary. So some states like Colorado and Maryland apply to employers with just one in-state employee. Others like Massachusetts and Hawaii kick in at 25 or 50 employees. Second, several states require more than just a wage range. Connecticut, DC, Maryland, Illinois, and Colorado require disclosure of certain benefits as well, things like paid time off, health insurance, or retirement options. And third, it's not just external candidates. Take a look at the screen. States like California and Washington, internal job transfers and promotions can trigger pay disclosure requirements too. Keeping it moving, the next group of states follows the same themes. Minnesota, New Jersey, and Washington all require you to disclose both pay and benefits. Others like Vermont and New York focus only on pay. Again, employer size matters. In Minnesota, you need 30 employees before the law kicks in, but in New York, the threshold is just 4. And don't forget, many of these laws apply to remote jobs or out-of-state ads. So just because your headquarters is in Texas doesn't mean a job posted in New York is exempt. Now let's talk about local laws, because cities and counties are getting in on the action too. New York City, New York City, Jersey City, Ithaca, they've all adopted rules that closely mirror their state laws. So the good news, if you're already complying at the state level, you're probably 3/4 of the way there locally, but you still need to do a little more work. Ohio takes a different approach. In Cincinnati, Toledo, and soon Cleveland, employers don't have to proactively include pay in postings, job postings, but they do have to provide it if a candidate asks, and only during the hiring process. A quick heads up, Cleveland's law takes effect in October, so now is a great time to review your job postings if you're recruiting in Northeast Ohio. The key takeaway, these laws overlap in ways that aren't always intuitive. It's not just where your company is located, it's where the job is, where the candidate lives, and sometimes where the ad appears. If you want more information about this, we have linked to our pay equity white paper in the resources section to this webinar. So check that out. There's also a lot of information that we posted to the HireRight blog, so give that a look as well. Let's talk about some common exceptions, because not every rule applies universally. For salary history bands, there's a few consistent carve-outs. If your candidate voluntarily discloses their pay history, that's usually okay, but you still can't use it to justify offering less. You can't use those voluntary disclosures. Internal candidates are often exempt, especially for promotions. Public sector or unionized roles may require disclosure due to statutory pay bans. Talking about pay transparency laws, there are a few exceptions. The exceptions include employer size thresholds from 1 to 100 employees, depending on the jurisdiction. Remote job triggers. Some laws apply based on where the work can be done, not just where the company is. Again, that's an important distinction, where the work can be done. So that's really broad, right? If you hire remote workers, then you're probably going to invoke the need for pay transparency laws regardless. There's also job type exclusions. Some laws exclude commission only or temporary roles. Disclosure timing, while most laws now require posting job pay ranges up front, some still allow you to wait until after interviews or after conditional job offers. When you think about this, think about these exceptions not as loopholes. They're not loopholes. They are legal boundaries. So your compliance strategy should balance legal requirements with consistent candidate experiences. That usually means setting your internal rules to the most restrictive standard that applies. So let's close with a few practical steps for salary history bands. You're going to want to share the pay range up front before or at the time of application if required. Don't ask for or rely on prior pay, even if the candidate volunteers it. Audit your application forms, recruiter scripts, hiring templates, and offer documentation to make sure this pay information isn't collected or used. Concerning pay transparency, you'll want to include wage ranges in job ads, especially for remote roles or posting in states like California, Colorado, New York, or Washington. Colorado's law is particularly nuanced. I've written about that extensively, so check out my articles on the HireRight blog or in Forbes for a comprehensive overview of everything you might want to consider for Colorado. You'll also want to disclose benefits if required, especially in Illinois, New Jersey, or Minnesota. Don't delay pay disclosures until after the offer stage unless a law clearly allows it. And if you're unsure, I always give you this tip: apply the strictest applicable standard. That protects you across jurisdictions and helps to ensure a consistent experience for your candidates, especially those considering remote roles. Because at this point, I would say pay transparency isn't optional, and pay equity, it's not this just arbitrary corporate value anymore. It's now what is legally expected by your candidates. So that is a very quick overview of our pay equity and pay transparency section. Keep engaging with us. Keep getting your questions in using that Q&A icon. Take a look at that pay equity white paper. And if you're really curious to do a deeper dive, do a Google search, a web search for our pay equity and transparency articles on either Forbes or the HireRight blog. So I'm going to hand it over to Nicole to talk about our next topic that's on the fringe: sex offender registries. Nicole? Oh, actually, I'm sorry. Age-related inquiries. I'm jumping ahead of myself.
No worries. Yeah, we're going to touch really quickly on this one first. So age-related inquiries and age discrimination. And we're really talking about the pre-employment stage here. So we're not talking about age-related inquiries once you've hired someone and you're getting, their date of birth to maintain their employee records and things like that. We're focused on pre-employment. So we're really thinking stages like your application, your initial interviews, things like that. So important to keep in mind as we go through this section. So at the federal level, we have ADEA, the Age Discrimination in Employment Act. This is the federal law that protects workers ages 40 and over in employment. So think things like hiring, promotions, things like that. Now, ADEA does not have an explicit ban on pre-employment inquiries about age. It doesn't say you, employer, can never ask for someone's date of birth until you've fully hired them. It doesn't say that. But ADEA is enforced by the EEOC, which is an entity that employers should be familiar with. The EEOC enforces a lot of things. Also think Title VII of the Civil Rights Act, another employment discrimination law. So should be a pretty familiar entity. And they have issued guidance, and their opinion on this practice is pretty clear. You can see a snippet of the guidance on this topic in the bottom left, and I won't read it to you word for word, but you'll notice as you read it that the EEOC really discourages the practice of pre-employment age inquiries. So federal level, no explicit ban, but it is discouraged. The EEOC has some great information on their website about ADEA and age discrimination, so I encourage you to give that a look. This is an important topic for all employers across the country, so give that a read on the EEOC's webpage. Now, at the state level, the answer is a little bit different. We actually have a handful of states who do have prohibitions on age-related inquiries in the pre-employment stage. So you can see a summary of each of them on the right-hand side of your screen. Again, I won't read them all off to you, but I do want to call a couple really important points out. First, the scope of these. So when we think age-related inquiries, I think a lot of people think, okay, I won't ask for their date of birth, and then I won't know their age, and that's the end of it. These laws go a little bit further than that and include graduation dates, and some of them actually even include dates of attendance at educational institutions. So something really important to keep in mind as you're analyzing your applications and interviews and your kind of onboarding program as a whole, to figure out if you're asking these types of questions. Keep in mind it may include education information. Also, something important to note, as I mentioned before, this is pre-employment. So most of these limit the time frame to applications and say you can't make these age-related inquiries on your application. Some will extend it a little bit further and say you can't ask until after a conditional offer, but they're not full-out bans for the entirety of someone's employment, from initial application to hiring to eventual retirement or termination. It's just in that pre-employment stage, so important to keep in mind. Now, as with most laws, and I think all of the laws we've talked about today, there are exceptions. There are only two, though, really, that are common with these laws. The first, of course, is if it's required by a federal or state law. That one's pretty common across what we've been talking about today. The second is if you have a bona fide occupational qualification. So this just means if you have some sort of reason that it is reasonably necessary to the kind of standard operations of your business, that you have to have this information in the pre-employment stage. Now, unlike the credit history section where we had all of those nice definitions for substantially job-related, we don't get that here. These laws don't all define what this means. So it's something that you will need to work with your internal teams, legal counsel, to really analyze as it relates to your own business and figure out how you apply that to your program. So best practices, do this, not that, for age-related inquiries. The first two bullets on the left-hand side of the screen in the do section, I think these are really good best practices to look at kind of as a whole with your application and interview process, but they're really important here for this discussion too. So in that initial application stage and your initial interview stage, think about focusing on skills and qualifications. Does someone have, the credentials? If you need a certain professional license, do they have that? Do they have the degree that's required, the experience that's required? And does their experience, do their qualifications align with the documented requirements you have for that particular role? That's really the key point of this stage of the process. So think about removing age identifying fields from your applications. Like I said before, of course, comply with the law is the best practice I could possibly give to you. If you're operating in a jurisdiction that prohibits you from making these types of inquiries on your applications, of course, best practice would be to not do that and take them off. But beyond that, keep in mind the EEOC's guidance and their stance on pre-employment age inquiries. Consider whether it may be a good idea and may be best practice to just remove them across the board from all of your applications. Also keep in mind that the states that do have laws on the books about this typically include graduation years. They may even pull in dates of attendance. So when you're going through your application and your interview questions, keep that in mind. It's not necessarily just, the initial PII section or the, about the person section where the date of birth and stuff would live that you'll have to look at. You may also need to look down to your education related questions too. Now that doesn't mean you can't ask if someone has a degree. Of course, education is a very valid qualification for a lot of jobs in many, many, many industries across the country and across the world. The laws don't say you can't ask if they have a degree. The focus is on dates and anything that you can use to figure out how old someone may be. So if you're asking a date of graduation from high school, perhaps you could do some rough math to come up with kind of a ballpark of what their age may be. Those are the types of things that you want to look for. So just keep that in mind as you're going through your applications. All right, now we'll move on to sex offender registries, our next topic. We're going to talk just a little bit about what they are, when employers might use them, and when there actually may be some restrictions on employers using them. So across the country, the states, the territories, and some of the tribes maintain their own public sex offender registry websites. I think most employers and most people are pretty familiar with these. Those who are convicted of most sex crimes are required to register on these public websites. Of course, it's public, so that means that you can go to those websites in your local area and search your local area. Now, early 2000s, 2005-ish, we actually saw the release of the National Sex Offender Public Website, the NSOPW, later renamed the Drew Shoden site in honor of a victim of a sex offender, actually. What this website does is it provides one central location to search most of those other public registries, the state registries, the territorial registries, the tribal registries. They're linked into this one central place. Now, the DOJ, the federal DOJ, runs the website, but they do not own the data and they don't maintain the data. So that's really important to keep in mind. What shows up when you search the NSOPW is based on what that state or tribe or territory contributes to the NSOPW, what they provide. They're responsible for maintaining the data, for keeping it up to date, and all of those things. So a key piece to keep in mind, and if you are searching the NSOPW and you think you find something, you might want to consider looking to the state, territorial, or tribal registry just to confirm it all. Another common thing we get questions on is, how do sex offender registries and criminal records interact from a reporting perspective? So if you order a sex offender registry search and a criminal history search on the same person, what happens? Will you see them both? Will you not? Of course, the answer is it depends. I finally got to say it in this webinar. I wasn't sure I was going to, but it really does depend. Registration timeframes for offenders vary, and they vary a good bit. And it's dependent on things like what they were convicted of, how many convictions they have, things of that nature. I won't bore you with all the details. But registration varies from 15 years all the way up to lifetime. Someone could have to register for the entirety of their life. And it's an ongoing registration requirement. So it's not just register once in the state that the person's convicted in and then kind of one and done. The state will take it from there. The offenders have to keep updating their information. If they move, they have to update it. So there's a lot that goes into that. Now with criminal record reporting, you'll remember that the FCRA permits convictions to be reported indefinitely, forever. But we have a handful of states that don't. They limit the reporting of convictions to 7 years. So if you have a lifetime offender who committed their crime 30 years ago, and then you have, so their conviction is 30 years ago, but they're currently registered, you may not see both of those things, or you may see that they're currently registered, but if it's a state where the reporting of conviction is limited to 7 years, you may not see the criminal conviction. So just something to keep in mind. There is a bit of interplay there, and reporting rules play a big role in what will and will not show up on your background checks. So as you're reviewing your reports, especially if you order both products, just keep that in mind. All right, Alonzo, do you want to talk about prohibitions, when employers may not be able to use these?
Absolutely. So let's look at 2 states that place strict limits on how employers can use sex offender registry information in hiring decisions. See them on the screen: California and Nevada. Starting with California. Under the state's penal code, that's section 290.46, the state created its Megan's Law website to provide public access to certain sex offender registry information, but California clearly restricts how that data can be used. So you'll see that rule. I've excerpted it on the screen for you. Except to protect a person at risk, use for employment is prohibited. So that means you can't use Megan's Law data to make employment decisions unless it's specifically to protect someone at risk. The law also prohibits the use of that data for housing, credit, and insurance purposes. There are steep penalties for violating the law. So this is what I want you to be aware of. There are actual damages up to 3 times the amount of harm, statutory penalties of at least $250 and up to $25,000, and attorney's fees and possibly exemplary damages. So really be cautious if you're using or considering sex offender data registry data from California. There are narrow exceptions that I want you to be aware of, most notably for positions involving substantial contact with children, the elderly, or dependent adults, or where another law requires the check. But unless one of those carve-outs applies, use of the registry for employment purposes is off limits. Let's shift to Nevada, which goes even further. Under Nevada statute, I've excerpted the rule there on the screen for you. Except as otherwise authorized pursuant to specific statute, a person shall not use information obtained from the community notification website for any purpose related to employment. That's a full stop. Unless another statute explicitly allows it, employers can't use registry information for hiring or for other common use cases like housing, loans, or education. So what's our takeaway? Public access doesn't equal employer access, right? Just because it's there doesn't mean it's fair game for screening. In California and Nevada, misuse, as I've identified for you, can lead to some serious legal exposure. So here are some common exceptions. This is when employers may be allowed to use registry or registry information. In California, there's a narrow exception, which I covered. If there's substantial contact with vulnerable individuals, but this has to be job related and consistent with business necessity. Nevada, again, the bar is even higher. You have to point to a specific law that authorizes use of registry information in the role that you're hiring for. Absent that, use is prohibited. So think about this. Unless you're hiring for a legally regulated role, like in education, healthcare, or childcare, NSOR data is likely off the table for use in these particular states. So let's talk about some practical tips for NSOR use. So do check your state laws. If you're operating in a state like California or Nevada, NSOR use is highly restricted, and relying on public data without legal authority can expose your company to civil penalties. Remember that using NSOR data can trigger your normal federal compliance obligations, so the FCRA applies. You'll want to conduct individualized assessment, even if the data, the registry data is relevant. Title VII still applies. The EEOC warns against blanket bans based on registry status, so you're going to need to show that the exclusion is job-related and consistent with business necessity. Like Nicole mentioned, don't assume a registry hit means that you're going to get matching criminal history data. Sometimes a person may appear on the sex offender registry, but their conviction doesn't show up on their background check due to look-back periods or jurisdictional limitations. Don't use NSOR as a blanket screen. Limit its use to roles that carry a heightened risk, especially to those involving vulnerable populations. And finally, Nicole mentioned this, verify your data. The National Sex Offender website is just a portal. Each state maintains its own registry, so if you find a potential match, you may consider confirming it directly with the originating jurisdiction to review its context. So with that, I'm going to quickly pivot into our social media discussion. Keep getting your questions in. I see Nicole busy there answering some of your questions live. Thank you again for the engagement. Let's talk about social media. I'll open by saying that we did include some information concerning social media searches in the resources section to this webinar, so give that a look. First off, what is social media screening? So it's the process of reviewing a candidate's public online presence across platforms like Instagram, Facebook, X, TikTok, and others. It's not about hacking into private messages or asking for passwords. If it's done right, it's limited to the content that someone has chosen to make public, posts, likes, shares, comments, or photos. Why would you as an employer want to use it? Because resumes can be embellished, people can rehearse interviews, references could be filtered. They only want to put those in front of you that have good things to say, right? And in some cases, access to public criminal records could be restricted or unavailable. California, I'm looking at you. So public social media content can offer valuable insight into behavioral risk, communication style, or whether somebody might violate your code of conduct or brand image. It's also a legal minefield. So the key is to focus only on workplace relevant risks and ignore anything tied to personal belief or lawful off-duty content. So just because a post is public doesn't mean you can use it freely. Let's talk about legal risk, starting with equal employment opportunity laws. Social media often reveals protected characteristics, race, religion, gender identity, disability, pregnancy, even family status. If that information influences your hiring decision, consciously or not, you could be violating Title VII of the ADA or other anti-discrimination laws. That is why it's risky to let hiring managers or recruiters review profiles themselves. Once you've seen protected class data, you can't unsee it. I always say that. What about union activity? The National Labor Relations Act, or the NLRA, protects employees' rights to engage in concerted activity. So that includes posting complaints online about pay, schedules, management. Even if the post seems disrespectful, if it falls under protected activity, taking adverse action could be unlawful. And of course, there is the Fair Credit Reporting Act, which we've talked about a lot today, so I'm not going to belabor that. But I will say EEOC laws, labor protections, and the FCRA all apply to social media screening. If you're going to use it, build compliance into the process. Don't think of compliance as an afterthought. I love a map. Let's address a different kind of legal concern, social media privacy laws. Over 24 states and 1 US territory restrict how employers interact with an applicant's or employee's personal social media, especially when it comes to access. So I've tried to distill this down into what you need to know. Most laws prohibit requesting credentials. So that means you generally can't ask somebody directly for their username or password. You can't require somebody to log in during an interview, and you can't ask for screenshots of their private content. Personal is the key word. These laws target personal use accounts. Typically, those used for non-business purposes is what I'd consider personal. Most likely don't restrict access to professional platform, but personal use is defined differently in each state, and enforcement limitations and interpretations vary. Private content is always protected. Even if the content is job relevant, you can't usually request access to content behind a login wall. So anything that's private has to stay private. Credential language also matters. There are some states like California, Arkansas, and Maryland that ban requesting both usernames and passwords. Others only mention passwords. And a few like Michigan and Wisconsin use these broad access language, which could cover even non-credential based access. So if you're hiring in multiple states, you're going to need to be cautious. Public content may be fair game, but requesting access to anything private is likely off limits regardless of the individual's role. Some exceptions, there really aren't many. There aren't exceptions for like safety sensitive roles. There's no automatic right to access somebody's personal social media. Access has to be narrowly tailored, tied to legitimate workplace investigation, or required by law. So you can't require blanket access. You can only seek what's necessary to fulfill your obligations, and you have to follow procedural safeguards. So let's wrap with talking about how you build a social media screening program that's both effective and compliant. Let's talk about a few quick takeaways. As always, stick to public job relevant content. Never request passwords, force logins, or ask for screenshots. Only review what's publicly available and clearly tied to job performance or risk. I would urge you to not let hiring managers do the review themselves. That opens the door to discrimination claims. If you do conduct your own reviews, do it through a trained team that's segregated from hiring decisions, or better off, use a vendor that knows what to identify and what to filter out on your behalf. That is the best solution so that you don't inadvertently expose yourself to protected class information. Again, once you see something, you can't unsee it. Use clear and consistent screening criteria. So define in advance what you're looking for, like threats of violence, discriminatory language, or evidence of fraud, and apply that standard in all roles. And don't act on lawful off-duty conduct in most places. So as we're getting a little low on time, keep getting your questions in. I'm going to consider that a wrap for our prepared content. A quick plug, as always, as you continue to get those questions in, we have several outlets of information for you to consume. If anything piqued your interest, check out our resource library, blog, or Forbes articles. And as always, snap that QR code and connect with us on LinkedIn, where I post a short video covering a new compliance topic every single week. So with that, Nicole, we have time for just a couple of questions. Any themes that you want to bring out from any of our sections?
We have a couple. I think the first one, we got a lot on pay equity in this session. So I think one of the big questions is what happens if a candidate voluntarily discloses their prior salary without any prompting in one of the jurisdictions where there's a pay equity or pay transparency law?
So it does differ by jurisdictions. Some jurisdictions provide us with very specific guidance, others do not. Generally, you cannot rely on a voluntary disclosure in order to influence other pay. That said, in some jurisdictions, if you've made the candidate a job offer and you've offered pay, let's say you've offered them $50,000 annually, and the candidate says to you, but I made $75,000 in my previous role, you can validate that $75,000 claim in order to justify higher pay on that basis. Quick nutshell for you there.
Very good. Next theme is if we have a legal requirement to ask one of these questions, this one can apply to all of them, prior salary history, inquire into credit history, or ask an age identifying question. Can we do it? And I think the answer is for most laws in most states, there are exceptions for when it's required, explicitly required by federal or state law. Would you agree for the sections you've covered?
Agree completely. Yep, you would have to validate the actual exceptions within that particular law.
And then I would say the last theme is kind of two parts, but we could probably combine them into one, which is figuring out which law applies and how to decide which ones. If you operate in a whole host of these jurisdictions that have all these different, sometimes conflicting or really different laws, or if you hire remote workers, so you're in one state and they're in the other one, how do you figure out which ones to comply with?
Yeah, so I would say generally speaking, of course, you're going to need to review that particular law to identify its jurisdictional scope. But I would say generally speaking, work location generally applies. Lawmakers write these laws to protect workers within their jurisdictions. So that is a very good starting point. And as I mentioned earlier, if you're ever conflicted, apply the stricter standard. It's better to over comply than under comply in all cases. So with that, that wraps it for today's session. We've hit a lot of ground: pay transparency pitfalls, age-related restrictions, social media traps, and how not to get burned by sex offender registry rules. Like I mentioned earlier, these might be lesser used screening tools, but they do pack some of the biggest compliance punches. So knowing where the landmines are, that's how you keep your program smart, sharp, and defensible. Before you log off, do us a favor. The survey at the end of today's webinar takes less than a minute, and your feedback helps us make these sessions even better. It is our report card, so let us know how we did. Watch your inbox. There will be a link to a recording of this webinar. Your SHRM and HRCI credit confirmations will also be headed your way next week. With that, on behalf of myself, Nicole, and everybody here at HireRight, thanks for joining us. We'll see you at our next Compliance 101 session. Take care and stay compliant.